Hi, chat. Hello. It is Thursday, and got a little done with some things this morning, and got some mid morning stuff done a little in the early afternoon, and something big dropped. Something that I know was covered back many years ago and was kind of a joke at the time, and now there's a resolution to it. So we're gonna get into it. Anyways, welcome here. Thank you for being here. My name is Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area. And today, well, we've got a criminal law topic, although it's on the appellate side of things. Jussie Smollett, as the great Dave Chappelle once named him. He was appealing his conviction from back in 2022, and we're gonna cover all that. But the long story short is his conviction got overturned, and it was reversed. So we're gonna go through all that. We're going to let everybody get in here real quick. Blade 2.0 says, now I don't mind raging yet, unlike the Lake and Riley trial. And Uncle Bob's Bees, I'm glad you're here. I don't know if you were going to be here tonight, but something came in the mail for me, and they didn't put at the P.O. box at the post office. They gave me 2 keys, and I didn't see the other one, so it's been sitting there for a while, Bob, so I apologize. But they're asking me why I didn't go pick up my other thing, and I didn't know what they meant. So there was from Uncle Bob's Bees a pair of flush cut nippers. So thank you, Bob. I appreciate it very much. Didn't have to do that, but thank you very much on that. So thank you so much. I just wanted to let you know that I did get them. I'm glad you're here. So thank you. Okay, so we're going to get into the Jussie Smollett thing now, guys. So if you remember back in 2019, Jussie Smollett made a call to the Chicago police saying he had been attacked by a couple of white guys who sprayed bleach on him, and they started punching him and attacking him. They started calling him the Empire faggot. And he also said they called him the N-word. And he claims they knew him from the show Empire, which was a show on Fox. And it's like, I really doubt it. But they claim these guys were wearing MAGA hats. Where did I put mine? Oh, MAGA hats. They were wearing MAGA hats. And as Nate the lawyer says so eloquently, they ran around screaming at him that this was MAGA country. To be fair, it is MAGA country. But it is MAGA country, but he also claimed they sprayed bleach on him, among other things. And he went to the police, and the police showed up. And if you guys don't remember seeing this, we're going to kind of start at the beginning, because I want you guys, if you guys don't remember this stuff, we really need to catch up. So here is the body cam of what happened. All right, guys. So here we go. So the police respond, and they're coming up to Jussie's penthouse. And remember, this is at like freaking 3 a.m. in a very, very cold time. There's like a polar vortex or something came through Chicago. So it was cold as hell. And it's like the end of January. So it's really, and if you guys don't understand, this area of the Midwest, this area of America, it like by the end of January, winter gets cold. February is like the coldest month of all, generally speaking. But anyways, here's Jussie.
Come on in, sir. Any weapons or anything inside the apartment? No. Okay.
And I forgot to mention, he says they put a noose on him.
So I explained to them how you were going.
So as you can see, he's wearing this thing that looks basically like a basketball hoop, a basketball bat, like basketball net around his neck. And it does, this is how he looks. Like they put a noose on him, and he just went back to his apartment and kept it on him. So it's not very convincing. Not very convincing at all, but here we go. So
Get something in. And the reason I called you because this. Okay. Do you want to take it off or anything? Yeah, I do. I just want to see.
she was transported one female official
There's
detective.
bleach on me. They put bleach on me.
Okay.
1872 Robert.
You're filming us, right?
Yeah, this is all being audibly and visually recorded.
You want them to take it off? They're filming you. Like audio. I guess when they didn't know they were walking, said, I don't want to be filmed. Okay, so can we turn it off?
Yeah, you're giving us permission to turn it off.
So they ended up turning it off, and Jussie claims he was out buying a Subway sandwich, which he still ended up holding. By the time the cops got there, his Subway sandwich was still in his possession. And he claims that these two white men attacked him. Very quickly, the police realized he was full of shit. Very quickly, they realized he was full of shit. As things progressed, the district attorney for Cook County at the time, Kim Foxx, Democrat, cut Jussie a deal. He had to pay for the cost of the investigation and a $10,000 fine and, forgive and forget. So what did he do from there? Well, the court and everybody else, all of us were like, what do you mean that's all you're going to get? He got caught lying. Well, political outrage and, caused an investigation look into this. And another investigation was opened and another prosecution ended up being opened. They was some judicial wrangling and they determined that that wasn't a proper dismissal. Things weren't properly dismissed on the record. They weren't done right. And Jussie hadn't paid all the money he paid, so the deal was null and void. There were a lot of issues in this case. But ultimately, he got charged with 5 counts of felony disorderly conduct. Now, you're thinking, how does that work? Illinois, it's the way they write their laws. Apparently, they have felony disorderly conduct, basically like felony obstructing justice. So he got convicted of those. You guys remember, he got convicted. He was sentenced to 5 months in jail, and he had to serve 30 days. If you guys don't remember, he at his sentencing hearing, we got this gem, this very famous gem of Jussie. This just I remember when this happened. It was so beautiful.
Do you have any questions?
No, I would just like to say to Your Honor that I am not suicidal. That's what I would like to say.
Okay.
I am not suicidal.
Okay.
I am not suicidal. I am innocent, and I am not suicidal. If I did this, then it means that I stuck my fist in the fears of Black Americans in this country for over 400 years and the fears of the LGBTQ community. Your Honor, I respect.
Oh, I forgot he's also gay. But yes, it did turn out that, well, he did lie. He won't ever admit to it, but he did fucking lie.
You and I respect the jury, but I did not do this, and I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself, and you must all know that. I respect you, Your Honor. I respect your decision. Jail time. I am not suicidal.
Okay. Mr. Uche, let me inquire, are there any post-sentencing motions you care to present right now?
Yes, Judge.
Yes, Ms. Widow.
Remember, that was in COVID, and we all had to wear those fucking retarded masks, too. God, time flies.
Defense would wish to present a motion to reconsider sentence
All right.
and file it in standard.
All right. It is timely filed.
Thank you, Judge.
And let me say, I've obviously considered the sentence at great length. And it's timely filed, so it's preserved for purposes of appeal. Motion to reconsider sentence is respectfully denied. And is there another, one second, Randy. Anything else? Just a second. Is there going to be a notice of appeal filed?
Yes, Judge. We filed a notice of appeal. We're going to be emailing to the clerk right now, to the office.
You doing it in standard? And are you going to be handling the appeal?
Judge, as of now, yes.
Well, you have to commit to
Yes,
handling the
Judge.
appeal
Yes.
through the appellate
Yes, we
court.
filed a notice
Okay.
of appeal.
All right. Notice of appeal may be filed. Charlotte, specification, restitution of fines. Oh, and also statutory DNA and cost. Else today? Yes.
Your Honor, if I may, in light of the notice of appeal.
Hey, Chad, I'm just going to skip ahead to where they actually take him away, because it's great again where he starts doing his little tantrum. Here we go.
Yeah, I'll talk to you about it. I'll give you yours.
Okay.
Okay. Sheriff, court is adjourned.
And here he goes again.
I am not suicidal. I am not suicidal, and I am innocent. I could have said that I was guilty a long time ago.
Now, one would argue that's a confession of guilt. I could have said it a long time ago, but I didn't do it. But that is Jussie's situation. So he was sentenced to 5 months of jail. He had to serve 30. 6 days in, he got released from his sentence by the appellate courts. And that's not actually abnormal because it takes a long time to have an appellate case done. And when you have a misdemeanor level sentence of, under a year, a lot of courts will cut you loose and put you on what's called appeal bond, basically. Because if they overturn it and they find out, yeah, God, the court below fucked up, well, what happens? We've already served your whole sentence usually. So that way you have a chance of not, because at that point, what do? They say, sorry, but hey, you were right all along. No, they're going to let you out. And then if it turns out you're right, great. But if it turns out you're wrong, guess what? You're going back to jail. So there is that advantage of doing that. So that's not abnormal for him. That's actually a very common thing that happens. Now, you might argue for black defendants in Cook County, does that normally happen? I'll leave that to Bob and Ali Mata. But I'm sure they could probably say not as much as you'd like. But in Ohio, that's a very common thing. So anyways, he ends up in front of the Supreme Court. And, oh my gosh, some of you guys. Anyways, he ended up in front of the Supreme Court of Illinois, the great state of Illinois. And we have an opinion to go through. So we are going to do that here, chat. We're going to knock this out. And then also later, if you want to stick around, we will finish up the Lake and Riley trial. It's where we are a day behind, but it's day 4. We get it's the end of the trial. We'll watch that starting about 5:30. Jay says, Sean definitely read my Nikita comment and couldn't show it on screen. I don't know. Which one did you say? Because I'll show it. I'm not afraid to. Hold on here. What did you say? Yeah, I don't see it. Sorry. Is that my Reign shirt? Yes. Actually, a lot of people are saying this is my Troon shirt because the Troon of Kiev wears a similar colored shirt. But anyway, here we go, chat. Here we go. In the Supreme Court of the state of Illinois. Someone said Jussie is Ricada, so I said Nikita. Well, I'm not gonna lie, you guys have been making some funny comments in chat. So, anyway, we're gonna get into this here real quick. We got 2 super chats. Rick Nikita says for $2, DC's MAGA country. Yes, and I forgot to mention, chat. He did get beat up, and it turns out he paid 2 of his. He had these 2 brothers as personal trainers. These big strapping black dudes. These barely black guys kicked his ass for a bunch of money, and he wrote him a check. Remember, don't write checks, chat. So in a way, he is like Nick Ricada. Nick likes big burly black guys as well. Jussie had some bulls, and Nick has some bulls. Jay says this is such an obvious hoax, Lamau. It was. And Ultra Mega Man says about Nick. Nick's not going to plea out. I doubt he does. And he might not be allowed to plea no contest tomorrow, so we'll see. Or next week. Jefferson Poe says, for $2, the sandwich and a rope combo was meant for Fogel. Oof. Yes. Fruitfly says, can they retry him? The TLDR of that is no. Double jeopardy applies, so he can't be retried. But we'll get to that. That's a very good question, and we're going to get to that here. So what do we see here? We see, and this is, all this right here, chat, is just from the Illinois Supreme Court and how they do their case numberings. But the state of Illinois. The people of the state of Illinois, appellees versus Jussie Smollett, the appellant. Now, you see this, the people versus the people of the state of Illinois. That's how things are captioned in many states. New York, California, Illinois, for example. It's the people of the state of Illinois versus Jussie Smollett. In Ohio, it would be just the state of Illinois. It'd be the state of Ohio versus Jussie Smollett. In other places like Kentucky, it'd be the Commonwealth v. Smollett. Some places it's state v. Smollett. It just depends on where you are, but it's all the same thing. Okay, so there were a couple of the justices in the Supreme Court here. One of them delivered the opinion. These justices here, 1, 2, 3, 4, and 5, concurred. The Chief Justice and another justice took no part in the decision, which I have the feeling there's some sort of normally there's some sort of issue. They felt it was necessary to recuse themselves. That's not abnormal. If they feel it's proper, they go ahead and do it. The appearance of a conflict and the appearance of impropriety is good enough to view things as improper, or maybe there truly were conflicts of interest, or for whatever reason they decided not to be involved. Carla Vega says, didn't the prosecutor know Michelle Obama? Oh, yeah. Kim Foxx is part of the Democrat establishment there. Okay, some of these comments. Now, the opinion says the public justifiably expects the state above all others to keep its bond. If only it did. And this is a case from Indiana in 1986, the Indiana Supreme Court, which that's a very interesting thing. They start off with that they start off with another state Supreme Court decision, but interesting. And they say, today we resolve a question about the state's responsibility to honor the agreements it makes with defendants. Specifically, we address whether a dismissal of a case by nolle prosequi allows the state to bring a second prosecution when a dismissal was entered as part of an agreement with the defendant and the defendant performed his part of the bargain. We hold a second prosecution under these circumstances as a due process violation, and therefore we reverse the defendant's conviction. So, short story, guys, complete reversal. The conviction's reversed. He cannot be retried. And honestly, if you're upset about that, great. Yes, it does suck. Jussie got away with it. But remember, those same rules protect you, and those same rules protect everybody. And this is actually good case law at the end of the day. This reinforces the notion that the state can't jerk people around. So there is benefit to this case, even though you may not like it. It's got far greater implications for criminal justice in general. So there's going to be some mope out there in Illinois who's getting jerked around by the system who might be able to rely on this and protect himself. And as I've said before, it is bad. Case law is not made by good people in good circumstances. Ernesto Miranda, for your Miranda rights, he was out raping women. He was a serial rapist. The exclusionary rule under Matt v. Ohio, Don King was running numbers, running his own little hood lottery, and the mob blew up the house that was being operated out of. There's, a lot of these court cases are not done by good people. That's how it goes. Now, the complete statement of facts may be found in the appellate court's opinion, and we're not going to go through all that. But they went through, ultimately, he was facing a 16-count indictment with felony disorderly conduct, and it was all because he'd falsely reported to Chicago police he'd been the victim of hate crime. Now, in 2019, 18 days later, the assistant state's attorney explained to the judge the state was moving to nolle prosequi the charges. The assistant state's attorney, which is an assistant prosecutor, explained the decision of the court as follows. The state does have a motion after reviewing the facts and circumstances, including Mr. Smollett's volunteer service in the community and agreement to forfeit his bond to the city. The state's motion in regard is to nolle prosequi, or you also hear it called nollied. If you ever hear in court attorneys or prosecutors or judges saying something got nollied, that's what they're talking about. Yes, Brady was a murderer and Miranda was a rapist. Yes. So, and Chet, that's a very correct observation, and we'll get to that. All right, so they keep talking here. We believe this outcome is a just disposition and appropriate resolution. Now, ultimately, it wasn't. It was a political thing, but hey, he says he does have an order directing the clerk of the court to release the bond payable to the city of Chicago to be sent directly to the city of Chicago's Department of Law. And there's an address and the person there who takes on behalf of that. The amount of the bond was $10,000. So Jussie forfeited his bond. The trial court granted the motion to Nolly and released the defendant's bond. And then in April, a retired appellate court judge filed a pro se motion, meaning he did it on his own. So a retired judge to appoint a special prosecutor in the matter of the people of the state of Illinois versus Jussie. The motion raised questions about the resolution of the charges and the manner in which Kim Foxx had recused herself. Because remember, if you guys don't remember at the time, she recused herself in such a way that she's like, I'm not touching it, but my office is. And that's not how a recusal should work. If you're out, your office is out. Because guess what? You're in charge of your office. So after briefing, a judge entered an order granting the appointment of a special prosecutor. In the order, the judge reviewed the case and wrote the disposition of the cases by way of a nollie had shocked officialdom as well as the community. Judge Tooman noted that both then Mayor Rahm Emanuel, Barack Obama's chief of staff, and then President Donald Trump had issued statements condemning the resolution of the case. Tooman specifically found that negotiations on the disposition had dated back to February, when the first assistant state's attorney, Joseph Maggots, wrote to the Cook County State's Attorney's Office. They could offer diversion and restitution, but they would indict if something could not be worked out. Oh, wow. That's a big fucking case plan. Sorry. Got an email. It pops up on the other screen. The chief of the criminal division told detectives that they could no longer investigate the crime, and she felt the case would be settled with the defendant paying $10,000 in restitution and doing community service. Judge Tooman then addressed at length the circumstances surrounding Foxx's recusal. Tooman found that once Foxx recused herself, the appointment of a special prosecutor was required. Instead, she appointed her first assistant to do it. The judge found that Foxx had appointed Maggots to an entity that did not exist because there is no legally cognizable office of acting state's attorney. So Tooman noted that if a case is not prosecuted by an attorney properly acting as an assistant state's attorney, meaning as an assistant prosecutor, the prosecution is void and the cause should be remanded for prosecution by a proper prosecutor. The judge cited these cases where proceedings have been voided because of prosecutions by unlicensed attorneys. Judge Tooman concluded there was no duly elected state's attorney of Cook County when the defendant was arrested, charged, indicted, or arraigned. Because at that point, she had recused herself. And if that's the case, there's nobody who can act until a special prosecutor comes in. And they say there was no state's attorney in the courtroom when the nollie was entered. Accordingly, Judge Tooman determined that appointment of special prosecutor is mandated to conduct an independent investigation of the actions or any person or office involved in the case and determine if reasonable grounds existed to prosecute. So the judge later appointed a guy named Dan Webb as special prosecutor. And then following the investigation, a special grand jury indicted Jussie on 6 counts of felony disorderly conduct. Which, once again, I still think that's so weird that you have that as a felony in some states. And in information as part of the release, the OSP explained that reasonable grounds existed to prosecute Jussie because he had planned to participate in a staged hate crime attack and thereafter made numerous false statements to Chicago cops, which he did. And he literally planned it all out. Now, I know some of you guys are asking, why did he plan it out? Why did he plan this out? Well, ultimately, the idea is he probably did this because the TV show Empire was doing pretty good, but they weren't paying him what he wanted. They weren't agreeing to what he wanted. He wanted a bigger role and he wanted more money. And they were telling him no. And people believe, and I think this is true, this is his way of trying to leverage them and kind of guilt tripping him into paying him more money. Basically, he wanted to use this to push his career. So, is this emotion or the decision? Jim, this is the decision itself. We're just going through the background because it brings up what happened. And I think it's important for us to know how the court looked at this. I think that's important for us to know how the court looked at this. Hold on here. Oh, wrong one. Hold on, guys, here. There we go. And just so people are, in case people are confused, we'll start there. So here we go. We're going to keep going, chat. We're going to keep going. Now, in the information release, they made a bunch of determinations, but they also determined there were problems with how the case got resolved. And the issue was that they argued they weren't allowed to do it. Eventually, Jussie moved to dismiss the indictment on double jeopardy grounds. The courts basically argued that wasn't correct. And they said, we're going to keep going because obviously he went to trial. Jussie argued that he had entered into a non-prosecution agreement with the prosecutors, and the agreement was executed and enforced. And that is true. Just like with Bill Cosby. If a prosecutor, especially if it's a written agreement, it's hard to overturn those. And he argued that the prosecutors were bound by the agreement. Because the prosecutors, the special prosecutor and the county prosecutor are both agents of the state. And Jussie performed his part of the agreement where he forfeited his bond and satisfied his community service. And then the state performed its agreement when the case was dismissed. So they also point out, and this is a good argument. This is actually a decent one. I thought it was at the time. Jussie argued that public policy supports enforcing agreements between the prosecution and the defendant. And it is true. It is kind of important that if plea agreements, those should be upheld. Dismissal should be upheld. Now, there was a bit of an issue here. The court stated that the judge had found there are really no state's attorneys running the show at the time because of the confusion caused by the recusal that was made. So the judge at trial stated it wasn't going to challenge the judge's order or his reasoning, and they could not dismiss it. So eventually, Jussie went to a jury trial. He was convicted of 5 counts of felony disorderly conduct. He was sentenced to 30 months probation with the first 150 days to be served in the Cook County Jail. The court also ordered him to pay a $25,000 fine and $120,000 in restitution to the city. And remember, he only served 6 days. So where do we get to from there? Well, there were a bunch of appellate arguments raised. The appellate court talks about what happened here. But the appellate court rejected all of his arguments and affirmed his conviction and sentence. And I think we talked about that. So we are going to keep going here. And the big issue was they determined that, and this was the interesting thing. They said that it's well established that law provides that a nulli prosequi is not a final disposition and doesn't bar a second prosecution. Interesting take. They said, however, the court stated that no Illinois court has ever applied the principles of contract law in interpreting the scope of a nully disposition in a criminal case, which I find hard to believe because I have made those arguments before in court, that there are contract principles, that there's estoppel, there's reliance, there's public policy concerns. What happened to Kim Foxx? She didn't run for re-election, no, but she made her money. So, Brimstone says the judges don't have to accept a plea deal, so why don't they accept a non-prosecution agreement? Because it's separation of powers argument. If a prosecutor says I'm not going to prosecute something, the judge can't order me to. Like, if I'm a prosecutor and I don't want to prosecute something, court can't force me to do it. I could say I decline to prosecute. I don't want to do it. That's enough. So the court can't do anything about it. I mean, that's the basic thing here. A prosecutor is a political entity. Sure, they are the executive branch of government, but they are elected officials. They are politicians. So they can wield their power politically in addition to ethically. And if it's a political issue, the court doesn't have the right to force them to do something if they're acting in a political way. So that's why they're allowed. That's why they have to. The court must suffer. To quote the great jurist Ethan Ralph. Brimstone says Kim Foxx often have authority to make the deal. Well, we're going to get to that. We'll get to that. Okay. Torgo says if the judge refuses the plea deal, that is. Well, that's different. A judge can refuse here's the thing. A judge can refuse a plea deal. Sure. But if the prosecutor says dismissed, guess what? The court has no power to reject that. The court has no power to reject such a thing. If I'm the prosecutor and you're a defendant and I look at the court and go, Your Honor, case dismissed. Judge can't say, no, you must prosecute this man. That's not how that works. They can't force you to do it. They cannot force you to do it. That's one of the interesting things here. And let's say a judge tried to. You know what I could do? I could go into court and I could throw it. At the end of the day, if that makes any sense. So I could literally go to trial and I could sit there, Your Honor, the judge could say, Mr. Martin, please present your case. And I go, Your Honor, the state of Ohio rests its case. We present no witnesses or evidence. And I would sit down. And then the defense attorney could go, Your Honor, we'd make a motion for a directed verdict. And the judge would have to grant it. He can't force me to put on a case. So that is why that can happen. So once again, a plea agreement's different than a dismissal in that area. Susan. Hi, Susan. You're going to bring this up now. We'll talk about it now because this is important. Can you explain what a nollie prosequi is? Sure. And thank you for the super chat. I do appreciate it. And I think I don't think I've seen you around before, so thank you. If you have, though, thank you for being here again. So a nulli prosequi is basically just a dismissal. It means you're not going to prosecute this anymore. Okay? I'm sure there's an actual Latin term, like a phrase, but it basically means you're just not willing to pursue the charges. You're just going to dismiss. That it's, you're no longer prosecuting. So once again, if you guys ever hear the term something gets nollied, or you'll hear me say it gets nollied, nollie prosequi is a thing. Now, it's interesting in Illinois, that's a formal proceeding or a formal way to do stuff. In Ohio, it's just a term. There's no special way to dismiss stuff. You just file a dismissal. So a nollie prosequi just means it's a dismissal, and that's it. And thank you again for the super chat. I hope that answers your question. So, I'm glad that answered your question. And here's the thing, Susan, I appreciate the super chat, but if you do put questions down below, I will try to answer them and catch up with them too. So, If you have anything else, let me know. And who just texted me? Hold on here. Guys, I gotta take this as a client. Sorry, this is kind of important. Idea. All right, sorry, chat. No, it's not a shower text. It's a client. And guys, I apologize. You know, my clients come first. I do appreciate you guys being here, but they still come first. So, and this is where the majority considered, and this getting back to the Court of Appeals opinion, the majority considered Robin says a signal okay for clients or PGP. I would be careful about using some of those things just because with Signal, messages can be deleted and you want to be able to have a paper trail of communicating with your client, especially if they accuse you of something. And normal text messages are fine because it's believe it or not, it's secure enough. If there's truly issues of truly important data, I would never communicate that over the phone or via text. Just because the phone could be, somebody could steal your phone or whatever. But the idea of somebody hacking and surveilling my text messages, I mean, yes, somebody theoretically could do that, but that's outside the capability of an average person. So I don't think there's an issue with using those. So anyway, here we go. Anyways, it's the Court of Appeals saying that there were several cases where there were agreements between the defendants and the prosecutors were enforced, but determined that they were all distinguishable. And that is the way, and I've said this before, courts of appeals are very good at saying, you know what? Your case sounds a lot like all these other cases, but yours, it's different. Why? Because we said it's different. It's distinguished. And not in a good way. It's distinguished in, we don't want to have to give you the relief you want, so go fuck yourself. And that's the way appeals courts work. So the court concluded the record was silent regarding any non-prosecution agreement between the prosecutor and Jussie, and the only disposition requested was a nolle prosequi, which does not impart finality. So their argument was because it didn't say this was meant to be final, a dismissal of prejudice, and this is meant to be a done and complete matter, or what the dismissal would cover any and all acts, their argument wasn't fully done. Now, there was a justice who dissented. He said he would have found the second prosecution barred the agreement reached by the prosecutors. And he made his own arguments there. He also argued the majority's contention that not only did not bar further prosecution was unsupported legally and factually, and he went through a lot of issues there. But now we're going to get to the actual analysis here. So this is the actual Supreme Court discussing things. And once again, don't ever do this, chat. This is called an orphan. Don't do it. Always hit Control-Enter and get it to the next page. It's a formatting decision. You got to format your documents right. So there are 5 arguments on appeal. 1, that he entered into a non-prosecution agreement that should be enforced. 2, double geopardy considerations precluded the second prosecution. So he'd already been punished. 3, the trial court erred in denying his Rule 412 motion to compel the prosecutor to disclose to the court for in-camera review its notes from witnesses and its interviews. His sentence was excessive and influenced by improper aggravating factors. And 5, the restitution order was an error because of problems of proof and because the city of Chicago and the police cannot be considered victims under the correct statutes. Now, notice the next sentence. they argue, well, hey, you win on point number one. We are not going to address anything else. And that is common because you've got an issue. You've got an issue where you win. So there are limits. There are limits. If the court finds something for it to work on, they will leave it at that, and there's no point to keep going. Oh, hold on, chat. Okay. Hold on. There's an order here. Sorry, it came out. Oh, the judge is just saying, "Ow." Yeah. Okay, that's actually kind of what I was hoping was going to happen. All right. So they say we agree with the defendant's first contention and therefore do not address the others. Appellate courts work this way. They found a reason that number one is correct. He entered a non-prosecution agreement. Well, you don't have to address the other issues. Courts do not want to address issues that are not relevant. The case gets reversed. They don't have to address the rest of it because it's dead. You win. You may offer 99 points. But if one of them is correct, they will address the one that's correct and the rest of them will go away. Courts do not make it a habit of addressing matters that are not in purview for them. So, all right, hold on. What are people? People are going crazy here. Now, they say that if Jussie's argument largely tracks the reasoning of Justice Lyle's dissent, and they argue a non-prosecution agreement where he fully performs as part of the bargain, and therefore any further prosecution was barred. And that's true. It should generally be that way. Jussie contends that public policy considerations support enforcing such agreements. He argues it's irrelevant the first case was disposed of by a nollie because the nollie was entered by the state as part of the agreement. Now, they go through all of this here, and defendants further contend if there's any procedural or structural flaws in the agreement, Illinois law requires the agreement to be enforced if the defendant relied on the agreement and his reliance had constitutional implications. Now, there's also another thing here that if Jussie did rely on it, it's their problem. But there's also a principle of contract law that goes like this. If there is any ambiguity in a contract or in a written agreement or a written document, you could construe the ambiguity in favor of the non-drafting party. Meaning, well, it could mean X or Y. Well, in that case, you give the tie to the base runner, not to the team playing in the field. So if the state has drawn up the document, it's against the state. Oh. You guys know I actually received real texts and real communications during the day. And then they say, finally, if this court has any doubts of the terms of the agreement, it should be remanded for the matter of an evidentiary hearing. And I think that's fair. If we don't know, it should be addressed. The prosecution argues the record does not show the nollie was entered into as any part of an agreement. And that's important. Remember, guys, the court speaks through its record. Without a record, there's nothing there. If it's not documented, it did not happen. Alternatively, the state argues, even if there was an agreement... Hold on. Who is this? Jeez. Not the winner. Court's like, you've won. I'm like, did I really win? I don't know. Alternatively, the state argues that to the extent there was an agreement, it was only for a nollie rather than a dismissal with prejudice. The state cites Illinois case law establishing that a nollie is not a final disposition, and it doesn't bar further prosecution. The state acknowledges that cases have enforced agreements between the prosecution and defense, and they say those cases all involve the defendant waiving significant rights. The state argues that an evidentiary hearing would not be appropriate because the defendant failed to develop the record establishing a non-prosecution agreement and never requested a hearing. And I will say, I think that from what I understand, that happened correctly that way. Jussie and his attorneys probably didn't do a good job at developing the record. And here's the thing, we see this now in all these cases. When you see attorneys sitting there establishing the record, doing proffers, laying foundation for things, you're developing a record so the appellate court can rule. If you guys remember the George Kelly trial, he was the rancher out in Arizona who shot the illegal alien, the guy who was helping smuggle people across the border. If you remember, there was a time where the judge walked off the bench and the defense was making a proffer. You make your proffer to make sure the Court of Appeals can know what you were trying to say, and it's on the record and documented. So it's very critical. It's very, very critical. They also argue that you can't challenge any of this because the circuit court said your first proceedings were void. But you still have the right to challenge that whole thing. Now, they say a reviewing court considers a trial court's ultimate ruling on a motion to dismiss under an abusive discretion standard. But where the issues present purely legal questions, the standard review is de novo, meaning it's reviewed in its entirety for all error. When the defendant was denied due process and whether the denial was sufficiently prejudicial, those are questions of law, and those are reviewed de novo. Given the trial court summarily denied defendant's motion to dismiss without resolving any factual questions or addressing the merits of the arguments, we believe de novo is appropriate. Now, they talk about a couple different cases here. So they start going through Supreme Court cases, Santabello versus New York. And ultimately, they say the Supreme Court held that when a plea rests in any significant degree on a promise or agreement from the prosecutor, so that can be said to be part of the inducement or consideration, such promise must be fulfilled. And that is contract law, where you make assurances or you hold out comments or statements or actions, and I rely on them to my detriment. You can be held to those things. It's a principle called detrimental reliance. I relied on that to my detriment. It induced me to commit to this contract because you made a promise or you made a statement. The courts have also consistently enforced agreements between defendants and the prosecution in a bunch of other contexts. Enforced agreements also include that charges will be dropped if you pass a polygraph. I've had those and I've dealt with those. Yes, prosecutors will make those agreements. Now, I will say this much. You are goddamn insane if you're willing to go to their polygraph guy, a police polygrapher. Now, there are times where I've had clients, we go to a private polygraph guy who the prosecution knows of and realizes isn't a kook, as a former cop himself, and you get through there and they, oh, he's, my client, you accuse my client of doing X, Y, and Z. Look, here's what I have, detective. I have proof he didn't do it. He passed the poly. And he passes the poly, and usually they look at that and go, well, damn. Yeah, that's good enough for us. But we never, I don't know why you'd ever go to a police poly guy. Whew, that would be scary as hell to trust a polygrapher like that. Because the neat thing is, if I do a private polygraph, I don't ever have to tell anybody what the results are. But if you, if you take the polygraph there, then the prosecutor knows you bombed. Oh. I take it good says a police polygraph sounds beyond loaded. Oh God, it's scary. It is scary in that regard. Oh, it is. It is really, really bad. It is really bad. Real quick, Robin Fox for $10 says, "What's a de novo argument in this regard?" And if I didn't make it clear, and I apologize for that, and thank you for the super chat, by the way. A de novo agreement is a complete review of the case. They disregard all the standards from what the appellate. Normally, they'll say we have to look at what the appellate court did, and then they do a right job. No. A de novo argument is you will look at all the evidence, the entire record, and you make your own decisions as though the other courts don't exist. It basically, you wipe the chalkboard clean and they redo the math entirely. Normally an appellate court would merely just look over the math and say it's good or not. For a de novo review, you write down what they got for an answer and you wipe the chalkboard clean and you work out the equation yourself and determine whether or not it was good. So I hope that makes sense. I hope that makes sense, Robin. Does that make sense? Robin says, "Please, polygraphs are easy. Have you ever stolen from an employer?" Okay, here's the deal. Polygraphs are voodoo. Have you ever stolen from an employer? I can put you in a room with 15 different polygraphers and they'll say all different kinds of answers because the line will go like this, boop, boop. And they'll say, "Oh, that's deception." That's not deception. It's entirely interpretive and there is no clear standard. So no, police polygraphs, there's a reason why they're not admissible in court. And I would never let a client voluntarily do a polygraph with the cops. Like I said, there's private organizations I can use to get the same thing. But Robin, I hope that makes sense. Literally, the court is going to take the entire thing, all the record, the transcripts, everything, and they sit there and they flip through it all and they determine what was legit or not. They don't merely just kind of like give it they don't just give it a once over. They literally build it up on their own. They point out that, enforced agreements that charge will be dropped if you pass a polygraph. Sorry, that was a hell of a detour, chat. If you obtain a psychiatric examination that produces certain results, cease criminal conduct. I've had that agreement before with the prosecutor. Tell him to stop. He stops. No prosecution. Usually you get that and I have that in an email. And that email is backed up and documented. That email is backed up on multiple accounts. That email has also been sent to my client, so he's got it. And we're coming up on the 2-year window for all the statute of limitations. And guess what? Like we're waiting until that happens, and then he's safe. That he aided a criminal investigation in some way, or even some additional test, is agreed to, and it did not implicate the defendant. Courts have employed contract principles. And while other courts would be held to a breach of the public faith to not hold the government to its word. And yes, the breach of the public faith is true, but contract law is far more easier to argue. And they say that this court already addressed a similar situation where the prosecution allegedly agreed to dismiss the charge against the defendant if the defendant would submit to and pass a polygraph examination. In his motion for a new trial, the defendant alleged that he passed the polygraph, but the state did not dismiss the charge. This court found the record insufficient to determine whether there was such an agreement, so remanded the case back down for an evidentiary hearing to resolve that question. And if the circuit court determined that there was an agreement, this court directed that it must implement the agreement by appropriate orders. So, they do point out that he's given a prosecutor has a great responsibility of evaluating evidence and determining what offenses, if any, could be charged. The prosecution must honor the terms of agreements it makes with defendants. To dispute the validity of this precept would surely result in total nullification of the bargaining system between the prosecutor and the defense. Therefore, this court believes that the prosecution did make an agreement. It must abide by its agreement. That's happened in other courts. The Michigan Supreme Court and the Florida Appellate Court have enforced similar agreements. So they talk about Michigan, they talk about in Florida. There's many states where this has been happening. At times, the prosecutors made arguments that it was simply a gift type bargain that lacked consideration, that they were just helping you out. This court explained that the consideration was the defendant surrendering his Fifth Amendment privilege against self-incrimination. In this case, the guy was doing a polygraph. Although they point out this court has also declined to require specific performance of agreements if the defendant has not yet pled guilty. And why? Because the defendant's due process rights may be protected by pleading not guilty and going to trial. And that's fair. Because if you haven't pled guilty yet, you can always change your mind, and the state can always change their mind. And you're still protected. But once you plead guilty, you've now done something you can't undo. You've said things you can't unsay. The court has also declined to require specific performance, and specific performance is a contract term, chat. Specific performance is, what is it that you agreed to do? So we write up a contract. I buy your house from you for $1 million. I give you $1 million. Okay, and you keep the $1 million, but you never give me your house. You never sign a deed. I can seek specific performance. And not that I want the money back, I want the house. I have the right to say, no, judge, we had an agreement in the contract. I want the fucking house. And the court will look at it and say, as long as the contract passes the state laws regarding valid transfers of land, they'll say, yep. And they'll tell you, hey, chat, give Sean your house. He paid you, fucking sign it over. But the specific performance of a plea agreement when the prosecution withdrew an offer before a defendant has pled guilty. And they explained that that was without a constitutional significance because the defendant did not plead guilty in reliance on the agreement. And that's true. If you haven't done the thing, then they can rescind the offer. Now, I fucking hate it when they do that. I've had guys where we set up a plea deal. Your Honor, we've got a plea. You email the court. We set a date. We come in, like the court schedules extra time. You know, the court sends me an email or calls me and says, hey, Sean, could you be here at this date? We're set for trial on Tuesday. I know that's like a week away. Can you guys come in tomorrow? And I look at my calendar. It's like, yep, I'll already be there. Sweet. We'll have your client there. So we sit down, we get ready to walk in and sit down. The prosecutor goes, well, funny thing, I got to withdraw the plea offer. You know, the judge is going to look around and say, this is bullshit. I'll say it's bullshit, but there isn't a whole lot I could do. My guy has not pled yet, so they can't withdraw it. Now, if he's pled, they're locked in. Now, the only way that they can withdraw their agreement is if you break the rules subsequent. So, for example, if you enter a plea and then you're out on bond and you violate conditions of bond, the prosecutor can reject a plea agreement. Or if you commit another crime or anything like that. But if you haven't done anything wrong, yeah, they're kind of stuck with it. So they go through a couple more cases here, but I think we need to get to what happened here. And where is here? And this gets to here. Part 1. The null and prosequi was entered as part of an agreement with the defendant. So the state contends there is no evidence for the nollie as part of an agreement. They argue that the forfeiture of the bond was voluntary, which is kind of hilarious. It's kind of hilarious. Because they point out that the record the state cites in its support of this, they point out that it's done under the circumstance of the bond was voluntarily forfeited as a condition of the dismissal of charges. So it may have been voluntarily forfeited, but it was done as consideration for the dismissal. They argue this is fully consistent with the position the charges were dismissed as part of an agreement. The only interpretation of the prosecutor's words is the defendant charitably agreed to give up his $10,000 bond at the exact moment the prosecutor coincidentally dismissed the case. And that's their argument here. And that's a fair argument. Why would I have just agreed to give up $10,000? Because the state's trying to argue these are two separate things. We're dismissing the case, and then Jussie's like, I'm giving up my money. But they did at the same time, and there's like a wall between them, so you don't know what happened. On one side's here, and on the other side is here, and they don't know what's happened. They've happened in a vacuum. No, they didn't, and it's clearly not. And the judge is right. This is not what happened. And they say, although we think it's clear that the statement alone, the nollie, was entered as part of an agreement with the defendant, we note the record contains even more support for the conclusion. The judge, who appointed the special prosecutor, addressed the negotiations entered into over the resolution. He wrote, there was no admission of guilt or plea when the agreement was consummated. And then, moreover, the special prosecutor revealed that there was an agreement between the parties. In the report, the special prosecutor noted and interviewed defendant's lawyer who negotiated the plea resolution. And the special prosecutor found there was a conflict over who negotiated the terms of the resolution with Jussie's lawyers. Two different state's attorneys stated that the other one negotiated the terms of the resolution with defense counsel, and defense counsel offered their version of which the state's attorney she negotiated the resolution with. So the report also states that the assistant state's attorney offered terms to the defendant, which he ultimately accepted. So there clearly was an agreement because they accepted his terms outright. Pay the money and we'll let it go. There was no back and forth. They just accepted it. Additionally, there was a press release. In the press release, the prosecutor states that it dropped the charges in return for Jussie's agreement to do community service and give up his bond. That's a pretty convincing point. It's not on the record in court, but this is the statement. God, we are getting snowed on. It is the statement from the prosecutor to the entire world. While that's not on the record, that's a pretty clear indication of what you are doing. Remember, chat, yes, what you say on the record is critical, but if you're going to tell the whole world, hey, I'm doing X, Y, and Z, that is considered an admission. Your own words can be used against you and construed against you. Oh, hold on one second. Yes, Nick Ricada, you should take note. The press release further states that without the completion of these terms, the charges would not have been dropped. That's I have not heard, I didn't know about this, but yeah, that's a pretty good indication you have an agreement. That you even know there was an agreement. Finally, the report notes that the statement the state's attorney read in court was drafted in conjunction with the defendant's attorney. There simply is no credible argument the dismissal was not entered as part of an agreement with the defendant. So, Forum says 2 ambulances Secret Service were seen leaving Mar-a-Lago. Saw it on X. Ooh. Yeah. Hopefully somebody committed seppuku. That's not anything bad. So the terms of the agreement, chat, and we're gonna kind of blow through this here real quick. But the terms of the agreement are clear. Community service and bar and forfeiture on the defendant's part and dismissal on charge of the state's part. Remember, with a contract, you have two parts. You have offer and acceptance. You have the offer and acceptance. You also have to have what's called the manifestation of mutual assent. And in contracts class, you write that as MMA for shorthand. Both parties have to agree and know what they're doing. If they both agree to the same terms and the same objectives, and they both know what they're doing, there's a manifestation of mutual assent. So this is a clear contractual agreement. So everybody agrees. Jussie gives up money and he goes and does community service. The city of Chicago dismisses the charges. There's together. What's that? Sweet. Oh, okay. Apparently the ambulance is nothing, chat. The Emperor is safe on the throne. The complete terms of the agreement are set more out in the Office of Special Prosecutor's report of its findings, and are virtually identical to set forth in the information release. So the charges are as follows. They dismiss the 16-count felony indictment. There's no requirement that Jussie Smollett plead guilty to any criminal offense. There's no requirement that Jussie admit any guilt or wrongdoing. In fact, Jussie stated he was completely innocent, which he's not. He fucking did it. 4, the only punishment for Smollett was to pour in 15 hours of community service. And that had no relationship to the conduct. And 5, Jussie only had to forfeit the $10,000 bond as restitution in the city of Chicago. And that is a figure less than 10% of the $130,000 on police overtime. The police were involved in doing this because, guys, they tore the city apart trying to find these guys that attacked them. And they said that there was no requirement that Jussie participate in the deferred prosecution program, which would have required a 1-year period of court oversight of Jussie. Now, deferred prosecution might also be known as diversion or call of prosecutor, COP, depending on where you're from. But basically, a deferred prosecution agreement is you wait out the clock, complete whatever the court wants you to do, and then at the end of that time, your case gets dismissed and sealed. That was not required in the situation. They just straight up dismissed it. I see you, John. How you doing? Yeah, man. Dude, get a hold of me. You got my cell phone. Hydra Fear says anyone dirt warrant went down in Mar-a-Lago. Doesn't sound like a big deal. Doesn't sound like a big deal. 2.0, my lovely producer, says don't worry about it. But anyways, they point out it's equally clear the parties intended finality. The state disagrees with this conclusion, but it appears pretty clear this is final. They argue, though, that the statements from the state's attorney in March clearly show the parties intended finality. Again, the state's attorney stated the outcome was a just disposition and appropriate resolution of the case. Disposition is a legal term. You're disposing of it. How are you ending the posture of the case? How is the case ending? An appropriate resolution. Once again, when you hear terms of disposition and resolution in court, that usually means it's over. Everybody in court understands we're done. There's nothing else coming back. So it's very important there. As the justice, the guy who dissented, explained, and they say it's cogently explained, meaning very clearly well put. While the state could have exercised greater semantical precision on the record by saying the case was terminated with no intent of refiling, from the record, it is apparent that was the intent. The intent of the prosecutor to exercise the authority of the state in crafting and tendering its agreed disposition of the trial court was evident. The prosecutor stated she believed this outcome was just disposition and appropriate resolution. And disposition is defined as the act or power of disposing or the state of being disposed, such as final arrangement or settlement. Now, see, guys, this is what happens sometimes. If you force the court to define things, they'll crack open the dictionary and go for it. And those words denote a finality that would not exist if the state merely sought to refile the charges. Yeah. And then ordinarily when the state disposes of a case, the file stays within exclusive control and possession. And they say the intent of the finality is also evident in the terms of the agreement, as set forth in the Special Prosecutor's investigation. Because they state the only punishment Jussie would receive is the 15 hours of community service and the forfeiture of bond. Using the words like punishment and restitution, they can note that the case is at an end. And that's true. You don't do restitution till the end. no punishment until the end. Everybody's agreeing it's over. That's why, remember, words mean things, chat. And you have to be very specific and very careful and very thoughtful when you use your words. Every time the special prosecutor had a chance to describe the terms of the agreement, it described that as a complete dismissal in exchange for punishment and restitution. The OSP noticed the parties agreed defendant would not have to plead guilty and would not have to participate in the deferred prosecution program. And they say, again, these statements connote a case resolved rather than one that is ongoing. So they point out that there was no indication anywhere in the reports the prosecutors intended to go after Jussie. And there's every indication that they consider the case resolved, which is critical. If the Cook County prosecutor said we're done, then they're done. It's pretty clear there. It's pretty clear at that point, chat. There's, like there's no. Yeah, I mean, they even discussed it with Kim Foxx, the state's attorney, the head prosecutor. She said that she was surprised by and disagreed with how the case was resolved. She believed the community service should have been related to the offense and Jussie should have to pay more than $10,000. She further stated if Jussie was not going to be required to plead guilty, he should have been required to admit to facts of wrongdoing. I'm thinking this is bullshit, and she lied to them. I wonder if those were taken under oath, because that means Kim Foxx committed perjury. She also told the special prosecutor that she believed the case resolved this way because they wanted Jussie out of town because of flurry of activity at that point and everybody that was coming into court. And yeah, they wanted him out of town and bury this issue. The special prosecutor also explained the various ways that the resolution Jussie received did not track the requirements of the deferred prosecution program. And they talk about what they did here. They talk about how this was done. And they talk about the press release that was also done by the prosecutor. More of it. So they're saying, we're not exonerating Jussie. The charges were dropped in return for his agreement to do community service and forfeit the bond. Without the completion, the charges would not have been dropped. And these statements indicate a case has been resolved. So it's done. Now, they point out that nothing happened after the initial case was dismissed makes sense if continued prosecution was contemplated. If, for instance, the prosecutor had nully prosequed and nullied the case because of evidentiary problems that require further investigation before they could do further prosecution, there would have been no public outcry. Yep. The retired judge would not have sought appointment of the special prosecutor. And further, the state's attorneys were contemplated would not have argued the disposition shocked officialdom as well as the community. So it's not only the statements, but it's the actions of the community and the perception of the community. So they're not even making the argument here, chat, that it's not just, well, technically in our legal parlance, it was dismissed. Everyone, and by everyone, chat, I mean everyone. Everyone! Like, we all thought it was done. We all thought it was dismissed. The public, the media, everybody thought it was done. And, if everybody's in agreement that it's done, I mean, that's a pretty good indication that it's done, right? If we all agree something happened, it happened, right? I don't think that's wrong. That makes a lot of sense. If we all agree, it's done. LPR, Tyler Yonke over at the Libertarian Podcast Review. I think he normally is 8 or 9 on Friday nights. Got stuff going on. Tyler, how you doing, man? He says, chat. And Uncivil Law, Kurt, how you doing, man? I don't know if you've seen this yet, but it's Pretty straightforward. It's a good breakdown of applying contract law and just how it, everybody agreed to the terms, so those are the terms. But guys, find Kurt over at Uncivil Law, and Kurt says the juice is loose. Well, he is juicy and he's a little loosey. Ugh. Ugh. Oh. You gotta hold on. Winter Soldier says, "What's the finalize my bet for tonight's toss ball game?" I mean, it's snowing right now, and I'm 15 miles from downtown Cleveland, and it's snowing here. I'm assuming they're getting snow too, but it's a light snow, but it's accumulating, and the snow's not melting. Even on the roads, we had a lot of cold rain today, so it's going to be a shitty night to play football. Well, it's a fun night to play football. It's a shitty night to watch football in the stands. And they say, anyways, we're going to get back to things here. Good luck with your betting. Do you want company to stream for a bit? Yeah, sure. Here, you know what? We only got about a half hour left, Kirk, because I got the Lake and Rally trial, but you're welcome to join us on that too if you want. But I'll send you something right now. Oh, we did? Oh, okay. There you go, Kurt. Just sent it to you. And then getting back to this here, chat. They say finally it defies credulity. Meaning this defies being credible for the state to believe that the defendant would agree to forfeit $10,000 with the understanding the prosecutor could just re-indict him the following day. And that's true. It stretches the bounds of credulity. It's impossible to believe that. And they say, well, a defendant might appreciate the gift of a nollie when not part of underlying negotiations, which sometimes happens. Sometimes the prosecutor, I've come into court, I want, hey, how you doing? And I'm getting ready to do my thing. He's like, yeah, we're dismissing. Okay. It happens. It happens. You're like, all right, well, we're not fighting it. Sometimes it's a gift. Sometimes it's a bargain. Yes, Chinny, we are watching our trial starting again about 5:35. So they said, why would a defendant bargain for uncertainty? When negotiating a disposition, a defendant is bargaining for the certainty that a plea or a cooperation agreement provides. Kurt, your camera's not on. Oh, there you are. Hey, Kurt, how you doing? Hello, Kurt, are you there? Can you hear us?
Hello.
Oh, I can hear you now. Okay, cool.
Excellent.
Okay, I was wondering. I was going to sign you that I can't hear you. Anyways, Kurt with Uncivil Law, how you doing? Uh-oh. Kurt, can you hear us? We can't hear you, Kurt.
I was saying how I was geeking out about this earlier on stream.
Oh, you were? Okay.
Because it was combining different aspects of law. You got yourself some contract law.
Yes.
Yourself some equity with some estoppel principles.
Yes.
You've got the detrimental reliance. It's like we just walked through our contract law analysis.
No, I know. That's why I was saying that too. It's I got to talk about manifestation of mutual assent, the bargain for exchange, all of that. And it's all here.
And I also liked, because I was geeking out on the fact that a plea bargain isn't considered basically binding until it actually happens, which I knew anyway, but it's just fun to have it spelled out. It's even though there's agreement, there's still no contract until you actually plead.
Yes.
So it's just these little things make me happy.
Yes. Although I will think this is kind of weird for Illinois. They count your headings as separate paragraph points. Normally it's just an actual paragraph of information, but that's a little weird to me.
And that is the least weird thing about Illinois.
I understand. Felony disorderly conduct.
I thought it was the rampant corruption.
Well, that's a feature, not a bug.
Yeah.
I like the Norm
Can you
Macdonald
believe this
there.
happened in Chicago of all places? Oh
Yes.
no.
Yes. Can you believe the Obamas were involved in this too? No way.
Next thing you'll be telling me it's Louisiana.
Yes. Now the issue is here, guys. The state is bound by its agreement, and now we've brought this up before, and I know Kurt. I think you probably talked about this too. Bill Cosby is a great example of this. The prosecutor made an agreement saying if you went and did the civil deposition, whatever you say there, we can't use against you. And then they turned around and tried to use it against him, and that's why Bill Cosby got out. They violated his right to remain silent by inducing him to go talk, and then they turned around and used it against him. So.
Yes.
The state, yes, if they make agreements and you actually go through with the thing, yes.
You know what the
they're
other
stuck
thing
with
that I noticed that was also in common with
Yeah.
Jussie Smollett and Bill or Cosby?
Yes.
In both cases, the agreement it's not in writing. This
Mhm.
is like it's like, hey, Sean, would you like to say these incredibly incriminating things? And
Yes.
your lawyers, if they have 2 brain cells, will be like, geez, that sounds like fun. Would you mind saying in a memo you won't use it against us first? Would you like to put it on a napkin and send it to us?
To be fair for Jussie, they wrote out the agreement and the prosecutor read it onto the record. So that's a lot safer than just having a memo. But yes, I agree. This should have been written out and signed. And the way this should have happened, Chat, and I think Kurt would probably want it this way too. All of this is laid out, and then it's signed by the prosecutor, it's signed by Jussie's attorney, and then it's done. And it should have been done that way. And probably signed by Jussie as well. But that's the way this should have been done. Because if they had that, this would have been dead a long time ago. But
maybe get it in writing is what I'm trying to say.
yeah. Getting in writing is never a bad idea. But I would argue there are things that were done. The record was done just well enough. But I think Jussie's attorneys screwed up protecting the record, but they did just enough to protect themselves.
Yeah. Also,
It could have been a
I
lot
really
better.
want to know where I can get in on this deal. This 16 felonies, what I can do is 15 hours of
Yes.
community service and also $660 per felony. I want to know, who do I have to write a check for?
Yes.
I'm willing to write a check today. I'll write you a check for $660. I want my felony hall pass. Also, I have a friend who is in need of a felony hall pass. So I'm willing to buy one for him. Where do I send my $660? Just asking.
Wait, you're friends with Patrick Melton? Oh. Well, I think the first thing is you need to. Never mind. I'm not going to say it. I'm not going to say it. Hold on. Are you talking to me? Are you doing work stuff, sweetheart? Oh, okay. Yeah. Sorry. She's talking. She's doing work stuff. I was really confused for a second. I thought she was making a smart ass comment. Oh, yes. A felony hall pass. Yeah. Don't be careful with those, chat. Be careful with those.
It's the new indulgences. Who knew?
Yes. Indulgences allow you to be degenerate. Yes, but the state is bound by their agreements. And yes, if there was an agreement as alleged, and if it's fulfilled, the state must fulfill its part. This court has held the principle for enforcing agreements as the due process clause of the 14th Amendment. And that's fair, but I would argue contract law is even easier. When the defendant acted to his detriment and reliance of an agreement, the state's required to honor the agreement as a matter of fair conduct. Yeah, and to allow the state to renege on the deal and bring new charges would be fundamentally unfair and offend basic notions of due process. Yep. I totally agree. It makes sense. It makes sense. And I forget if at the time I think they did him dirty. Because I think at the end of the day, I will admit I got a little wrapped up in watching Jussie Smollett get drug over the coals. Because he deserved it. I don't know. I don't remember how I felt
It
at the
irritates
time.
me that the deal did not include even an admission of the underlying facts,
Yes.
let alone a guilty. So he can
Yes.
continue to say, I'm innocent. That
Yes.
very much irritates me.
Yes. Well, we covered that at the beginning where he's getting drug out of the courtroom. He's like, I'm innocent. I could have pled guilty long ago. And I'm like, that's an admission of guilt, in my opinion. But yes, and I do think it's, the state making the argument the bond forfeiture was voluntary.
Yes.
Doesn't make sense because it's
Voluntary.
arguing they happened like in separate rooms at the same time. No, he gave up $10,000 for a very specific reason.
Again, these
Yes.
deals might seem very attractive to a number of felons.
Yes.
It's like,
And-
who do I write the 10,000?
Yeah, how many guys in Cook
Holy
County
shit.
were like, can I get that too? But I will say at
Yeah.
the end of the day, this is helpful for protecting a lot of criminal defendants going forward. I think this helps quite a bit. And I think I mentioned this before, Kurt, and I know you'd agree. Good guys aren't the reason why we get good case law. Like Miranda. Miranda was a very bad guy. Brady was a really bad guy.
He's a little shaky.
Giglio was not a nice guy. Map, Dolray Map, she was not a nice lady.
I don't know about Map. I don't know about the history of Map.
Dolray Map was in Map v. Ohio. Don King was running a numbers racket.
Oh, Don King. You could have just stopped it there. I'd be like, oh,
yeah,
okay.
well, yeah, it was Don King. He was running a hood lottery, and he wasn't cutting in the organized crime on the they weren't getting a skim of the action, so they blew up the house where the numbers were being run out of.
Cool.
Yeah, and the police, when the bomb went off, the police went in and they seized all the documents. So that's why we have the exclusionary rule now, because of Don King, chat. So they keep on hammering on this, and they say under these circumstances, dismissal.
How do you say these italicized words? Because I always struggle.
Nolli
with it.
proseque.
Nolli proseque.
Proseque. Yeah.
Proseque.
That's how we say it. That's how it's been said where I started practicing, and I've heard it that way. But where I'm at, you just hear the word nolly. Stuff gets nolly.
Everyone says no pros. I always hear it no pros. It's like I don't know how to pronounce the actual phrase.
Nolli proseque.
Okay.
I don't know, but like where I'm at in Ohio, if you say like, "Oh, Kurt's case got nollied," everybody knows what you're talking about. Because if you said like, "Oh, Kurt's case got nulled," you're like, "What?" You might say, "Wait, what do the farms have to do with the case?" If it got nulled. But yes, they go through this, and then finally, guys, we are running out of time here. I thought we had a little more time to get through this, but the biggest thing here is they disagree with the state's position. The dismissal means they could have brought a second prosecution. And this goes back once again to the agreement, the bargain for exchange, and that there are terrible policy consequences that would follow from adopting the state's position. And I agree. I mean, it's true. There's a lot of problems here. And yes, this is a fair argument too. The judge saying that the agreement was null and void doesn't preclude Jussie from relying on it, because we could say that judge was wrong. Just because the judge says I don't like it, well, that doesn't mean he was right. So,
I mean, void is a legal conclusion.
yes, it's void. And is it void or voidable? Because the judge may call it void, and it might be voidable only. And if it's voidable, chat, there's two different types of things here. It could be void or voidable. If it's void, it's flat dead. But if it's voidable, you don't have to kill it. You can let it stand.
Yes.
Now you're saying, well, if it's wrong, shouldn't it just be wrong? And it's like, you're not wrong about that. You're correct. If it's wrong, it should just be killed. But once again, this is why appellate courts exist. They figure out ways to keep the status quo upheld, because if they actually did their job, they would literally set afire the justice system by doing the right thing. So they won't do that because it's the right thing. I'm just saying. And I say that knowing that there's a guy I know who just won election to be a judge, and he watches me every once in a while. I'm like, sorry, but he feels that way too. So,
some judges are full of themselves. Some judges are wrong sometimes. Although, to be fair, judges are human beings.
yes.
So what do you expect?
No, you can't void a bull, KJ. No, not that way.
If judges remembered they were human beings more often, we'd probably be
Yes.
better off.
Yeah. Oh my God. Yes. But anyways, we're gonna get to the conclusion here, chat. We're gonna fly through it. We're aware this case generated significant public interest, and many people were dissatisfied with the resolution of the original case and believed it to be unjust. Nevertheless, what would be more unjust than the resolution of any one case would be a holding from this court the state was not bound to honor agreements which people have relied. And once again, circling back to Bill Cosby, as the Supreme Court of Pennsylvania recently stated when enforcing a prosecutorial promise not to prosecute. It cannot be against. It cannot be gainsaid. Is it gainsaid? Is it that a word?
Yeah. Yeah.
Oh, okay. I learned something today. It cannot be gainsaid that society holds a strong interest in the prosecution of crimes. It's also true that no such interest, however important, can ever eclipse society's interest in ensuring the rights of the people are vindicated. Correct. Society's interest in prosecution does not displace the remedy due to constitutionally agreed persons. And once again, chat, we can't go after the people we hate just because we hate them. We got to have rules.
Can one of the rules be that we can go after the people we hate?
Yes, we can't. That can't be the rule. Justice must be done, or may the heavens fall, is really what should be there. And that's basically saying it. Let justice be done, or may the heavens fall. A contrary result would be patently untenable. It would violate long-cherished principles of fairness. It would be antithetical to and corrosive of the integrity and functionality of the criminal justice system we strive to maintain. They say that, and then I guarantee you in the next 4 or 5 appellate decisions they give, they're just going to absolutely fuck somebody over. So I know they say this, but the fact they can say this with a straight face is very concerning to me. So we reverse the judgment of the appellate court. We reverse the judgment of the circuit court, meaning the trial court, and we remand the cause with directions for the circuit court to enter a judgment of dismissal, meaning don't pass go, don't collect $200. Jussie is done. It's over. It's dead. Have a nice day. Judgment's reversed. Cause mandate with directions, meaning they have to do this. This is not a suggestion. That is a court ordering it. Yes. AFIX says SMS messages are not encrypted. You're correct. They're not encrypted, but there is a significant degree of, if the public in general, if like a 10-year-old could figure out how to intercept text messages, yeah, I probably would use encrypted applications. But because it's not that easy to do, I'm not worried about it. It's considered, using text messages is considered acceptable under my malpractice insurance and by the state bar. So I'm not worried about that. But I appreciate the concern there. So yeah, we were talking about some other things back and forth earlier. Let's see. So we got a couple minutes, Kurt. Ultimately, I assume you agree with that decision at the end of the day?
I do.
Yeah,
I do.
And it sucks. There's nothing.
My only reservation to this
Yeah.
is it's at least to me, it does rest on a perhaps unspoken assumption that that Jussie Smollett was perhaps more innocent in this machination coming to be than I think might be true in reality.
Oh, I think so.
Like, I don't know that I can necessarily prove it, but I think that Jussie Smollett allowed this to. I mean, there were text messages between him and Kim Foxx, as I'm
and
sure
Kim
you're aware,
talked to Michelle Obama.
And so I don't think it's quite the same, because I think that I don't think it works if he's a conspirator in the creation of the thing that he benefited from. Well, and I think that might be more true than is on here.
I 100% think he was and it does give you problems, because we all don't get to interfere in the justice system like that. Most of us, we'd be sitting there just like Scrooge McDuck, walking circles into the floor of our house, waiting for, oh my God, what are they going to do? So as Fruit Fly Sadist asked, are they going to retry him? There's nothing to do. It's over. Double jeopardy. Bye. Last Imperial says, can be tried in under Admiralty court. you're going to have to go capture them and try them. Yes.
I was speculating on my channel there might be a federal cause of action, but if there was, I think the statute of limitations for it is long since
Yeah.
expired.
SB
So that's
Sellers brings up.
unfortunate.
Yes. SB Sellers brings up there's no rules about triple jeopardy. I'm like, well,
Technically, this decision didn't rely on double jeopardy.
it
relied
did.
on it relied on due process.
Yes. But yes, there is a triple jeopardy. You could try them again. Try the third time.
Mm.
Jefferson Post says protect the scumbags' rights, protect everyone else. Yep. Have to do it that way. Chet Manley, and this is an issue of, kind of just philosophy here. Doesn't this mean a corrupt EA can let their allies get away with anything by agreeing to drop charges? Yep.
Yep.
The prosecutorial discretion is a massive power. I mean, guys, if you don't like, I want to make sure you understand this. Nicholas Sandman, or no, not Nicholas Sandman, Nicholas Cruz. Wrong Nicholas. Nicholas Cruz, the guy who shot up that high school down in Florida. The prosecutors could all look around and say, if I was the prosecutor of that county, in Broward County, I could sit there and say, you know what? I'm not going to prosecute this. Let him go. And that's legal. Ted Bundy. Hey, Mr. Bundy, good luck. Have fun out there. John Wayne Gacy, go have fun out there. I don't have to prosecute anybody. I don't have to. And hold on, Chet. I need to.
My camera is glitchy. Not exactly sure what glitchy means, but okay.
You're a bit blurry, Kurt. You're running at like 240p. It kind of looks like for a second.
Okay.
So, but yes,
well.
Chet, the prosecutor can decide not to prosecute cases, and there's a political check on that. You can vote him out. But as I talked about earlier, the court can't force you to prosecute a case. So, because if I'm the prosecutor, I could walk in the morning of trial and sit there and say, Your Honor, are you ready for opening remarks? I could say, Your Honor, we waive opening. And the court could say, okay, we'll present your case. I say, Your Honor, we rest. And the defendant can go, they haven't presented a case, and guess what the judge has to say? Case dismissed.
Yeah, right.
There's not, that's how it could go. The judge can't tell you, no, you must do this. Fair Frozen says Jussie may walk, but now he's a radioactive N-word. Yes. Yep, he has no career after that. Jim tells you, and Jim, this is a big point, and I wanted to bring this up, and I hope you're still out there. There was some political implications tied to this. Kamala Harris, then Senator Harris, and Cory Booker, Senator Booker, they had an anti-lynching bill ready to go when this happened. I remember that coming out too.
Where's that anti-lynching bill now?
He got dragged. You could argue. Jussie was right. This is MAGA country, though. Yeah, I guess at the end, who got the last laugh? Brimstone says, isn't there an oath of office? The oath of office is that I won't violate the Constitution. I mean, you could argue that I'm upholding the laws of the state of Illinois by not, if I'm not prosecuting, is that upholding the law? Well, once again, that becomes a discretion issue. Do I think this is upholding the law means X, Y, and Z? Maybe I think it means something different. So that's how I mean, like I said, that's going to be the argument there. And courts are going to have to defer because that's a political question at the end of the day. Robin Foxx, a new member. Thank you, Robin.
This is one of the reasons that Soros spent so much time and energy on electing prosecutors in the first place.
Yes.
That's where a lot of these decisions are being made.
Mm-hmm. And guys, I've said it before, and you've heard other people say it too. Your county prosecutors and your local judges wield immense power, especially in your daily life, because it dictates how you govern yourself. Vote and go on juries. You will control how your local government takes care of itself. Waxing Miracle says, can you save me from Keir Starmer? I'm sorry, mate. I think you're going to have to save yourself at this point. But I don't think he's going to last that long. So you guys can do it. You can do it. Dragonstar has been gifting 5 memberships. Thank you, Dragonstar. I appreciate that support and the generosity. Thank you. Iman Reza says the police can't be victims is based. Well, for the purposes of restitution, yes, and that the government can't seek restitution, I think is fair. I think that's an appropriate way to do it.
No, I thought the Supreme Court didn't rule on that issue, and the lower courts, I believe, ruled that they could be victims under the relevant statute,
Yeah.
which I thought was correct given the reading.
No. We were talking about something earlier. I forget where we were because we read a bunch through the beginning of it to help make you understand it. Luke says, to be fair, granting the dismissal means the rest are moot, unlike other cases when this is usually bullshit. Yeah, but once again, guys, courts, they have an issue. The case, they can decide it on issue number 1. They're not going to decide the other 100.
Yep.
They let sleeping dogs lie because they resolve the issues. They don't want to resolve things they don't have to resolve. It's not issue preclusion. What's the principle called?
Constitutional avoidance, or just
Well, yeah, it's an avoidance doctrine. Yeah, just we don't have to address things if we don't have to address them. We have an out. And I've done that before. Like I got appeal. We made like 15 arguments, and argument 2 was. They said argument 1 doesn't work. Going in order. Number 2, congratulations, you're getting, judgment reversed. Arguments 3 through 15 don't care. So, Robin, we already asked that one, but yes, de novo means a complete review of all the facts and all the decisions. Craft of Forgotten says, I can lie straight through a polygraph. Ice cold veins like a schizophrenic. People say that, but like a real polygraph is tough. You're basically getting grilled by the police in a polygraph. It's not an easy interview because a polygraph has the polygraph part, but then an interview part of it. It's not easy. It's not easy. C says, can the questions and answers asked during a polygraph be used against you in court?
No.
Well, but he says, but they're not allowed to say if you're found to be telling truth or not, or am I making that up? So the questions, like certainly whatever's talked about in the polygraph room, you can't mention any of it. Now, let's say you took a polygraph with the police and then later on you sat in an interview room with the police and the police just asked those questions of you again. Those are admissible, but anything in that room is inadmissible with the polygraph. You can't mention the word polygraph. If you start to say Paul, like you're immediately, the judge is going to crap his pants. Somebody's going to say, if you say Polly, if you get that far, you're probably getting a mistrial. Polygraphs, you can't even mention the word. That's why, like, mentioning polycule, like, you've got to, like, that, like, you got to be careful. That "pa" is a very dangerous thing. You can't, it's, if you're a Harry Potter person, that's like Voldemort. You can't say it.
I just said in chat, someone said I'm drunk or high, and I'm just like, I get no love. I'm neither of those things. I went
You're
to the
just having a
gym.
good day.
I had a nice exercise.
There you go. You just
I'm feeling relatively good.
You got some endorphins.
We got some endorphins going on. That's nice.
Yeah. Yeah.
Why can't I just be in a good mood?
Yeah. Just relaxing. It's Thursday. And how warm is it down there in Houston?
It is 70 degrees.
Yeah, okay. Well, it's like 29 and snowing here. Oh God. Winter Soldier, if you're still trying to make bets, dude, there's gonna be snow on the ground. It's accumulating here. Oh. Benjamin Lewis said, did Jussie commit any federal crimes? I mean, maybe you could argue conspiracy.
Arguably, there's some hate crime. Yeah, conspiracy for a hate crime. Yeah.
Yeah, with the Osendiro brothers, and if he had actually hurt anybody, conspiracy to violate civil rights. But yeah, I think by this point, I think the statute of limitations is gone. So
yeah.
And besides, you have to find a U.S. attorney.
His face is red. My face is always red.
Yeah.
Face is always red.
Yes. Robin Foxx says
I've got whatever Trump has, except instead of orange, I've got red. So less yellow in my face, I guess.
Yes. Robin Fox, thank you, Robin, is saying OPM, the Office of Personnel Management, the federal level, leaked biometrics and polygraph digital files, questions, answers, response records in the standard format. I'm surprised they did that because some of those might be highly classified depending on the specific person and what their clearance was for. But okay, whatever. This is when the OPM was hacked by China. Sigh.
Wasn't it a while ago though?
Oh yeah. But yeah, the government. Who better to protect your information than the government? They'll never mess.
Yeah,
that up.
all the OPM files got hacked and released. Yeah,
Yeah.
that's a lot of
I'm
information.
hoping they're saying it didn't happen again.
That'd be bad.
Yeah. Robin Fox gifted 5 subs. Thank you, Robin. Thank you for your support and your generosity. Suki loves her nose ring. Tawdry is a new member. Thank you. Thanks for the support. And then Suki again for $10 says, for Clyde and Laney, some sweet hemp treats. Sorry, I can only afford half of a treat. These things I don't think are worth 20. Are these like $20 a thing? But anyways, yeah, guys, these things on Amazon, Nature Vet, these things are great for chilling out your dogs. They're all natural, so you can't overdose them. Thank you, Suki. Jasper the Cat says, Suffolk, Chicago. This is Smollett country. Well, Chicago is Democrat country, so yes. Chicago is suffering. Very true. Robin Fox says for $10, due process considerations, admit to the event and associated stuff. I would want it in black and white, even with counsel. Yeah, no, I agree. This should have been written out and signed. But yeah, the prosecutor didn't want all that. They, obviously Kim Foxx says, I was surprised. Like, I'm sure you were.
Sure you were, Kim.
Yeah.
Yeah, we all believe you.
Yes, but they can work out whatever you guys. You are pretty much free to work out whatever kind of agreement you want with the prosecutor. You can agree to legal fictions. I mean, I've talked about this before. And I don't know if you've heard it. I had a case once, and I'd only been like an attorney for about a year at this point. I had a case where the guy was accused of stealing from his grandma, and his grandma was 65. So therefore, it was an elevated theft offense because she was a person in protected class. And we were trying to figure out a way to make it a lower level felony and then put it in he could get a diversion program. Well, instead of trying to dismiss it and re-indict it, which that was just going to be a mess, we just changed her birth. We just agreed factually that her birthday was 1 year later and she was 64. And the court looked at us and you guys are making that amendment. He's like, okay, you're making it. Fine. You guys have made an agreement. At the time of the offense, she was 64. Therefore, this is not enough. And it was done.
Isn't that violated duty of candor or something?
No, because it's a legal fix. We agreed that it's a fact. It's a stipulation. At the end of the day, we could stipulate to a fact. This guy, and also I think it helped. This guy was very sympathetic, and the judge was very much like, okay, I get what you're trying to do. But it's a stipulation.
I remember that the Attorney General of Virginia once promulgated an opinion that a person turned a year older the day before their birthday for some reason. I'm not sure why they were asked, but I remember this being a thing. It's like you turn the year older the day before your birthday. So I guess if you want to go drinking at 21, you can drink a day earlier. In Virginia.
Yeah, I would love to have that argument in hand going to the bar, but I don't. I don't know. Chugi's saying I'm a bit behind, but the Mar-a-Lago thing was a false alarm. Yeah. Colton, we're going to end on this here, chat. Can we stipulate that Nick gets to Frank's hearing? No, I will not stipulate to that. Midnight saying the year completes the day before.
That's what the Virginia Attorney General said once.
You know what? I get that. I understand the argument, but if you gave me a kid who was caught drinking beer the day before his 21st birthday here in Ohio, I don't think I'm getting a court to buy that argument. They're going to say guilty. I mean, I'd probably get a jury to say, yeah, we're going to cut you solid, but yeah, no. I mean, God, I'd love to make that argument. Actually, Judge, it's a year before. It is you that is wrong. It's like, I don't know if that's going to work.
I tell you what, though, I recently had a traffic ticket in Texas, and I noticed some discrepancies on the forms.
Yeah.
Yeah. Yeah. Do you want me to tell you?
Sure. What did they miss?
Oh, it was interesting. So I pled nolo,
Okay.
and they said if you keep your nose clean, then it'll get dismissed, which I did, and it got dismissed.
Okay.
But on the actual agreement, it said you only have to keep your nose clean within Texas. But on the affidavit of compliance, it said
Yeah.
I've kept my nose clean in Texas and any other state and political subdivision. I'm like,
Mm-hmm.
oh, so it's like, yeah. And then they're also very self-aware because they're like, well, this ends on midnight, this date, but you can't actually submit it till the next day. There's like lots of little problems on it.
That
Because it's like,
sounds that sounds like other people have litigated that issue. That's why it's there.
yeah, but it's yeah.
Huh.
So there's issues.
Interesting. I thought you were going to tell me you pled no contest, and the judge looked at it and it's like, oh well, this actually doesn't count, so I can't find you guilty.
No, but I didn't
I've
get
had
into
that-
any. I didn't get into any other trouble,
Yeah.
so the case has been dismissed.
There you go.
So, yeah.
I had that. I was going to say though, I've had that happen a couple of times where we were in the public defender's office and the police in Toledo, they charged like some homeless guy with a disorderly conduct or obstructing. And we just walked up there and said, Your Honor, we plead no contest. And the judge he has to open the file and he reads the complaint from the cop and he goes, okay, you enter plea no contest. I find you not guilty, and they throw it out. And there was a way to not go to trial. Every once in a while you could, but it's so factually deficient. But what did they mess up on your thing? Did they mess up like your date of birth, your name, or?
Yeah, no, they just were like it was an incongruity in the forms. Let me see if I can
Yeah.
find them. I'll show
Oh,
you.
actually, did you have a watermark on your car? Was there a watermark on the ticket, Kurt? Maybe that's what it was. Or Garrett, you're right. The COG issued the tickets. COG, you mate? Are you out here becoming a Bobby, running
All
traffic?
right, so it says on the actual conditions of deferred disposition. I'll show you in a second. One of the conditions is receives no moving traffic violations in the state of Texas during the term of the deferral period. I don't know if you can see that because the light, but take my word for it. That's what it says.
Sure.
It says receives no moving traffic violations in the state of Texas during the term of deferral period. And then on the actual affidavit of compliance, it says, declares to me that he or she has not committed an offense. So that's one, because it said traffic violations.
Yeah, so if I
That
get
was
an
just
equipment,
an offense.
yeah, what if I get an equipment
So that's
violation
one.
or my plates
Against
aren't-
this state
yeah.
or any other state or political subdivision. So we went from don't commit a traffic violation in Texas to I haven't committed any offense in Texas or any other jurisdiction.
Well, it's not even a
so
traffic
the
offense.
affidavit is broader than the agreement was.
Yeah, don't
just
commit
trans.
anything. Can't get pulled over for anything, cited for anything. Yeah, not even for like plates or your registration going bad or an equipment violation.
Yeah.
So
And then it says, from the period of August the 5th and ending after midnight on November the 3rd. But then it says you can't submit it till November the 4th. But I'm like, after midnight on November 3rd is November 3rd.
yeah,
There's only one midnight on November 3rd.
yeah.
It's the very first thing that happens in the day is midnight. So,
And-
but it says don't submit till November the 4th.
And
So
this
because that's not when midnight is, man.
No, it's
midnight
not.
happened 24 hours earlier.
And this was another argument I made with contract law. When there's an ambiguity, it's construed against the drafter. Hey, state of Texas, you wrote this thing. It's your fault. Nobody can understand it. Therefore, I think Kurt's reasonable in what he did.
So I'm just saying they have
Yeah.
problems in their language.
Oh, they do. They do. They do. But at least it's in English. We can read it. So. All right, guys. So we are all caught up. Thank you all for being here. Kurt, thank you for being here as well. If you guys are here and you guys are new, today is Thursday, and Thursday night tonight at 9:30 Eastern, we are going to do the live show. We do a weekly show. Got lots to talk about. We're going to briefly touch on Jussie Smollett, just, explain briefly what happened. But we got updates in Trump's RICO case, Trump's New York case, Daniel Penny's trial. Some interesting stuff has come out. The Lake and Riley verdict. Nick, I'll finally talk about his appeal tonight. The YSL case is done. Finally.
No, it's not.
Well, the presentation of evidence, we have closing arguments Monday.
Oh.
Yeah.
Oh, I thought you meant like the case has been
No,
dismissed
no,
or
no, not
something.
done. No, no, no. A bunch of charges got directed verdict, though, surprisingly.
Yeah. Okay.
Andrew Tate's case, the top G in Romania. Some things have happened there. Not exactly what you may think. Susan Smith, her parole hearing, she got denied. We're going to talk about that. Alex Jones and his sale of InfoWars. The bankruptcy court has gotten involved, and we'll talk about all that and a couple other things. That's tonight at 9:30. From here, though, guys, we are going to move over to the Lake and Riley trial. Remember, Lake and Riley was the co-ed over at the University of Georgia. She was out.
I think the guy did it.
Yeah, I think he did it too. He was out. She was out for a jog, and he, tried to rape her. And when that didn't work, he murdered her. And there's not really allegedly, Chad. I mean, when you watch it, it's pretty obvious he did it, and there's really no argument that he didn't do it. So, that happened. It was a thing that happened. And we are catching up. We are behind one day. We're starting day 4. It's only half a day. We'll be done before the 9:30 show. The defense is wrapping up. There'll be closing arguments, and there'll be a verdict. Spoiler, he got convicted. But I do think it's interesting to see just they have so much evidence against this guy. Like, literally, they have him filmed walking around campus trying to, rape and murder other women all morning long before he finally kills one. I don't know if you've seen any of it, but it's, really bad.
I'm not. That's
bad.
disturbing.
Kurt helped save Alex Jones.
Well, the bankruptcy court is here in Houston, so hypothetically.
And Brooke says, can we talk about the the MIRVs from, oh, yeah. Well, we'll talk about that a little bit tonight, too. Yeah, Russia decided to say, hey, look at our multiple independent reentry vehicles on a nuclear missile.
MIRVs have been a thing for 40 years.
Yeah, I know, but we finally saw one get deployed.
Oh, okay.
Yeah, the Russians sent one to Dnipropetrovsk last night, and you could watch them. It's they were inert, but they were just showing we're done.
I've never seen a MIRV actually deploy. That'd be cool to watch.
Well, you can watch just the reentries is pretty neat. Robin says, Kurt, can you practice law in all Texas counties? I might have an ask for pay.
Okay. Well, you can send me an email at kurt@uncivillawllc.com. kurt@uncivillawllc.com. Let me know briefly what you are looking for, and we can go from there.
Yeah, there we go. There we go. You guys meet up kurt@uncivillawllc.com. So, all right, guys. So with that said, Kurt, thank you again for being here. Kurt at Uncivil Law here on YouTube. And guys, just remember till next time, Jussie Smollett did it. He was 100% guilty, but I guess he gets away with it. So,
Sad.
Oh well.
Sad.
I'll see you guys. I'm going to redirect you guys over to Lake and Rally chat. I'll see you guys there shortly.
All right, bye-bye.
Bye, everybody.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty.
Your consent is not needed. You'll do it because I'll make you do it.
But please talk to a local attorney. Was that the fat guy?